Hello, hello. Hi from Toronto. Hello. No tube of you. Yes, yes, I will. I don't know, everybody. This is a bonus right now. I'm still planning to come back on at 7, but I'm having some computer problems with my tube of you. So this is a bonus TikTok live at the moment. Super early, super early. But I had a really interesting, imagine that. I know, Kristen, right? Right? So, had a very interesting motion come down. I thought I would go through with everybody. So this again is just a bonus here. This is the time that I had to go through it. I did. It's great to see you. Oh, thank you. So, yes, I'm currently having it worked on. So we will see. I will either be on the tube of you or back on TikTok at 7 at my normal time. So this is just kind of a bonus here. It's doing better. I have been able to take the brace off for a little bit. So I'm feeling much better about it. Yes. Oh my goodness. Yes, it's a bonus. So yes, it is. My poor computer. Yeah, because the way the chat works for Tube of You is very different than here on TikTok. So I have to have a computer working. So the videos on Sydney Powell and Jen Ellis, I did. So, yes, both of those clips have made the rounds. And actually, Judge McAfee has had a hearing today. So that will be something I will be going over. We're going to kind of be doing some, I'm going to be doing going through this motion and then hopping back off again, then probably coming back on. But yes, but we had an interesting motion actually filed by the defendant, by Schaefer, and then everybody else kind of signed on to it regarding this protective order. And then we did have a hearing today. And it was discovered who it was. Is that Candy Cane? Well, kind of. It was discovered that we had, it was Misty Hampton's attorney who released it. It's a boba tea. So it's not, it's not a Candy Cane who leaked it. It was Misty Hampton's attorney. So yeah, they leaked it, and the judge was like, well, what'd you do that for? And they're like, well, we just want everybody to know everything. And he's like, okay, well, now we're going to have a protective order. So I will be going over that later on tonight. But yeah, it was a pretty significant moment. Again, to think that those kind of proffered statements would be okay, that's pretty significant. Yes, I have a plethora of writing utensils. True. Okay, so here's the bonus for tonight. I will be back again, everybody. So I'll take you through this motion, but I will still be coming back here at 7 o'clock my normal time. But this is kind of a little extra. I was going to try to stay later tonight, but I think coming on earlier will help. Excuse me. Does the attorney not get into trouble for releasing that video? So that's a great question. First, there was not specifically a protective order in place when they released the information. So there's that. But on the other hand, it is kind of private discovery. They should have known better. So I think Judge McAfee was like, you know what? I gave you your chance here. So we're going to put an order in place. Yeah, we've got one. It's in place now. So, and I will be going through that in a little bit. But what I wanted to hop on and share with everybody, I wasn't sure if you'd heard this or not, but Hunter Biden has filed a motion. So he's filed a motion for the issuance of subpoenas, ducis tecum or tecum. You know, I never say Latin correctly. It's not supposed to be spoken, right? But this just means produce a document pursuant to Rule 17C and a memorandum in support. So there's a lot of really interesting things coming out, including the interview that Trump just did where he was making statements about going after his enemies if he was to be reelected. So I thought I'd go ahead and go through. The judge said, this is why we can't have nice things. Exactly. Exactly. Oh my gosh, perfect description. So let me walk you through this motion here, everybody. To kind of, yes, we're doing it, to kind of give you an idea of what all of this means. So again, this is kind of a bonus here. I wanted to take some time and go through this with everybody, but I will be back again at my normal time. It was Misty Hampton's attorney. Yep. All right, so defendant Robert Hunter Biden, through his counsel, respectfully moves this court to enter an order directing that subpoenas be issued to the following individuals. So this kind of a subpoena means, look, we're going to be calling these people in for depositions. We're going to be asking them questions. And so when they come in, or when they come in to testify, whatever is going to be happening, they need to bring documents with them. That's what the subpoena is asking for here. The whole 1,700 pages. No! Oh my goodness. That's too much. I know. I'm trying to break apart the New York court testimony to figure out what will work out the best. All right. So here are the individuals that are going to be called that he's asking for production from. Donald John Trump, William Barr, Richard Donahue, Jeffrey Rosen. Pursuant to Rule 17C of the Federal Rules of Criminal Procedure, and that each subpoena recipient be required to provide any responsive documents and materials by December 1st of 2023 to allow Mr. Biden sufficient time to review the material in advance of any necessary pretrial motions, evidentiary hearing, and or a trial. The grounds for this motion include the 4 subpoenas to be issued as set forth below. Because the documents sought relate to one another, in both form and substance, this memorandum encompasses all 4 subpoenas. So we had a similar subpoena request out of the DC case by Mr. Trump, where he was asking for production of documents as well. So this is the rule. We have Rule 17, which governs subpoenas, and then subsection C, which governs producing documents and objects. So they can request a witness to bring in books, papers, documents, data, or other objects that the subpoena designates. And again, this is trying to get more evidence as they're going through their process here. So that's the rule. So let's go through his argument here. And let me just move this over a little bit here. I'm still trying to get everything set back to how it was. All right, so here's the introduction. Law enforcement agents have testified that the federal investigation of Mr. Biden, led by the U.S. Attorney's Office in Delaware in conjunction with other agencies, began in late 2018 during the administration of then-President Trump. That wide-ranging investigation has spanned 2 administrations and lasted more than 5 years and remains ongoing. That probe included, here we go, investigating years of Mr. Biden's tax affairs, as well as events surrounding his purchase of a firearm on October 12th of 2018, and its recovery by law enforcement 11 days later. The culmination of this 5-year inquiry was prosecutors and Mr. Biden agreeing that he would plead guilty to 2 failure to file misdemeanor charges, as well as entering a diversion agreement resolving 1 count of unlawful possession of a firearm, an agreement on which the prosecution has now unilaterally reneged. So again, if everybody remembers, we have that original plea agreement that kind of fell through here. The collapse of that agreement and the prosecutor's change of heart eventually led to the 3-count felony indictment against Mr. Biden, currently before this court. But the initial investigation was born out of a wider probe into Mr. Biden's taxes and foreign business dealings. Additionally, it has been reported and revealed in the now public IRS investigative files concerning this case, released by the House Ways and Means Committee. So let's make a note of that. We have a press release here out of the House Ways and Means Committee. So they actually released that information to the press. That separately, the Department of Justice under then Attorney General Barr opened a dedicated channel of the U.S. Attorney's Office in Pittsburgh to receive information about Mr. Biden coming from President Trump's personal attorney, Rudolph Giuliani, and his associates. And footnote 2 goes into a letter from the Assistant Attorney General, Stephen Boyd, to the Honorable Gerald Nadler. So, again, just going into that information. So, back up. The effort to review and vet any material was coordinated by then U.S. Attorneys Donahue and Scott Brady in Pittsburgh. When Mr. Donahue was elevated to serve as President Principal Associate Deputy Attorney General at the DOJ in July of 2020, and later in December of 2020, Deputy Attorney General under Mr. Rosen, IRS files revealed that he further coordinated with the Pittsburgh office and with the prosecution team in Delaware. Okay. Including issuing guidance regarding overt steps in the investigation. So we've got footnote 3, and then we're bumping down to an affidavit number 3 that's been attached. As Deputy Attorney General, Mr. Rosen interacted with teams investigating Mr. Biden in both Pittsburgh and Delaware. It led up to the 2020 election. IRS case files showed certain investigative decisions were made as a result of guidance provided by, among other things, the Deputy Attorney General's office. Testimony and investigative files provided by the IRS agent Gary Shapley also reveal that around the 2020 election, all aspects of the investigation needed to be vetted with the USA Weiss and DAG Donahue. So, and again, they're just making citations to where those claims are. In addition, public reporting reveals certain instances that appear to suggest incessant, improper, and partisan pressure applied by then President Trump to Messrs. Rosen, Donahue, and Barr in relation to an investigation of Mr. Biden. For example, on December 27th of 2020, then Deputy Attorney General Donahue took handwritten notes for a call with President Trump, and Acting Attorney General Rosen, showing that Mr. Trump instructed Mr. Rosen and Mr. Donahue to, quote, figure out what to do with Hunter Biden, end quote, and indicating Mr. Trump insisted that, quote, people will criticize the DOJ if he's not investigated for real, end quote. Again, they're citing these handwritten notes here. These notes were released by the House Oversight Committee as part of the January 6th investigation. Additionally, former Attorney General Barr's latest book, recalls an instance in mid-October of 2020 in which President Trump called Mr. Barr and inquired about the investigation of Mr. Biden, which Mr. Barr says ended with Mr. Barr yelling at Mr. Trump, quote, damn it, Mr. President, I am not going to talk to you about Hunter Biden, period, end quote. That was theatrical reading. And he's citing this particular Washington Post article down here. The confirmation of communications, these confirmations of communications give more than a mere appearance that President Trump improperly and unrelentingly pressured DOJ to pursue an investigation and prosecution of Mr. Biden to advance President Trump's partisan ambitions. For his part, Mr. Trump has made a plethora of concerning public statements calling for an investigation or possible prosecution of Mr. Biden, both while in office and since leaving, that further suggest improper partisan political demands were at play either expressly or implicitly. See also U.S. Code Section 7217, making it a felony for the president to request an IRS investigation of an individual. The former president has also incessantly called for law enforcement, the media, and the public to go after Mr. Biden. For example, he tweeted or posted the following about Mr. Biden. All right, here's the tweet, November 15th of 2020. Democrats must apologize to USA Ukrainian Foreign Minister Vadim Prystaiko, said the United States Ambassador Gordon Sondland did not link financial military assistance to a request for Ukraine to open up an investigation into former VP Joe Biden and his sons, Hunter Biden. All right, so that's the first tweet. Next tweet, December 12th. Why didn't Bill Barr reveal the truth to the public before the election about Hunter Biden? Next tweet, December 12th. If Biden gets in, nothing will happen to Hunter or Joe. Barr will do nothing, and the new group of partisan people coming in will quickly do this to it all. Same thing with Durham. We caught them cold spying this and more, the hard part, but justice took too long. We will be DOA. Okay, next tweet on the 17th of December. I have nothing to do with the potential prosecution of Hunter Biden or the Biden family. It's just more fake news. And then next, on June 20th of 2023, wow, the corrupt Biden DOJ just cleared up hundreds of years of criminal liability by giving Hunter Biden a mere traffic ticket. Our system is broken. Boy, these tweets. Well, thank you, Sheila. Boy, these tweets really have an element of anger to them. Next tweet, a sweetheart deal for Hunter and Joe as they continue their quest to get Trump, Joe's political opponent. We are now a third world country. You know, there's actually a definition for third world countries. I'm just going to put that out there. All right, this actually is a definition for that. Next, the Hunter-Joe Biden settlement is a massive cover-up of full-scale election interference scam, the likes of which has never been seen in our country before. A traffic ticket, and Joe is all cleaned up and ready to go into the 2024 presidential election. Right? Yeah, it's a lot. It's a lot. And the next tweet was July 11th. So just this past July. Again, this is a verbatim tweet. Weiss is a coward, a smaller version of Bill Barr, who never had the courage to do what everyone knows should have been done. He gave out a traffic ticket, which, by the way, this is that's not how the law works. It is not a traffic ticket instead of a death sentence. What? Wait a minute. I should have pre-read that. Hold on. Let's back it up here. He gave out a traffic ticket instead of this? Wow. Oh, my goodness. Because of the two Democrat senators in Delaware, they got to choose and or approve him. Maybe the judge presiding will have the courage and intellect to break up this cesspool of crime. The collusion and corruption is beyond description. Well, it looks like you described it. 2 tiers of justice, which again makes no sense. So dramatic. I know. My goodness. My goodness. All right. So those were the tweets. Okay. Oh, my gosh. Vocabulary is very limited. Well, it kind of feels like it. This call for Mr. Biden to receive a particular type of sentence and other incendiary comments are just a few examples of Mr. Trump as Mr. Trump made other similar statements at his rallies, on TV, and in his post-presidency. According to such statements by Mr. Trump while in office or since then necessitate and provide ample justification for this set of requests for documents, communications, and personal records relating to or concerning Mr. Biden. As referenced in the above posts, there has also been a substantial, almost nonstop public pressure campaign led by Mr. Trump and his allies in Congress to criticize DOJ's handling of this case, specifically the agreed-to plea deal between prosecutors and Mr. Biden that first made public on June 20th. After Mr. Biden agreed to plead guilty to resolve 2 tax offenses and negotiated a diversion agreement with prosecutors on the firearm charge, later signed by both parties in court on July 26th, Mr. Trump blasted the agreement as a sweetheart deal, a traffic ticket, and a massive cover-up. House Oversight Committee Chairman James Comer, who has made Mr. Biden a centerpiece of his committee's investigation, slammed DOJ for giving Mr. Biden a sweetheart plea deal and deemed it a slap on the wrist. Senator Rick Scott of Florida called it a mockery of our legal system. That's interesting. And Senator Ron Johnson said it was a light slap on the wrist. Upon news that the parties' agreement was not approved on July 26, Republican allies cheered and claimed responsibility, touting their role in intervening to do this to the deal. House Ways and Means Chairman Jason Smith told Fox News that afternoon that justice is being served, and later said a special counsel only happens because congressional GOP exposed the 2-tier judicial system. Okay, this 2-tier judicial system is just bologna sandwiches. By shining a light onto the investigation into Hunter Biden's alleged financial crimes and the political interference that shielded both him and POTUS from scrutiny. So... yes. So again, 2-tiered, I don't think they understand what that means. That's the rich versus the poor is how that is. And I don't think that's applicable here, but whatever. From that point forward, Republicans pushed for more severe charges against Mr. Biden from the now special counsel in an effort to make Mr. Biden's prosecution of an election issue. The outside pressure culminated in Special Counsel Weiss's then changing course and bringing this indictment on September 14th against Mr. Biden, charging 3 felony counts for the same gun and same facts that just a few months prior Mr. Weiss had agreed to divert under a pretrial diversion agreement. Wet work. Ooh, that makes me very uncomfortable. I believe your name is setting that out. So Daisy, do you want to go ahead and bump? Oh, did you bump him already? Okay, thanks. Yeah, if anybody has a name that is threatening like that, moderators, I'm just pausing for a minute here. If there's a name already gone, oh, Daisy, you all are so amazing. Just pausing for a minute here. I know a lot of people have been, frustrated with being muted, but we have, there have been so many issues here, and our moderators just take so much flack, just horrible comments against them. So I have given them permission to do whatever they need, and with 100% of my support behind them. So if you do get muted by accidentally saying something that they took wrong, put an emoji next to it so they know you're just kidding, because we do actually get death threats here, and we do actually get terrible threats against us. So we are very careful and have some PTSD about it. So if you get muted on accident, just please note it should be for 5 minutes. But if you say something that is violent or threatening, we will mute you. And my moderators, again, do their absolute best and are subject to a lot of really terrible comments. So they have my full support. I'm just setting that out there for everybody, okay? So just kind of putting that there. We don't really debate politics here, but if there are any threats or even any threatening names, that's okay, moderators. If you want to go ahead and mute, block, you do a great job. Here we go. So, yet Republicans now say this is not enough. The very same day that Mr. Biden was charged in this case, Chairman Comer stated, "Mountains of evidence reveals that Hunter Biden likely committed several felonies and Americans expect the Justice Department to apply the law equally. Today's charges are very small start, but unless U.S. Attorney Weiss investigates everyone involved in the fraud scheme and influence peddling, it will be clear President Biden's," here we go, "DOJ is protecting Hunter Biden and the big guy." Again, and these footnotes are just specific citings of those quotes. So this was from an article, a piece done by ABC News. "It is clear no measure of charges against Mr. Biden will ever be enough to appease Chairman Comer and Smith and their MAGA allies. As anyone can readily tell, it is not just pressure from within the Trump-era executive branch that is the problem. It is also incessant, unrelenting outside interference from congressional Republicans and their allies in the prosecutorial process, which is supposed to be independent and free from political interference. Undoubtedly, the current political climate has jeopardized that long-standing and fundamental American principle. Consequently, Mr. Biden now moves this court to issue 4 subpoenas directing Messrs. Trump, Barr, Donahue, and Rosen, individually the subpoena recipient, and collectively the subpoena recipients, to produce the following documents and materials in their possession pursuant to Rule 17C for the time period January 20th of 2017 to the present." So here we go. We will get into some more details here. So this is what they're requesting. This is what Hunter Biden is requesting in his subpoenas here. All right, number 1, all documents and records, personal or official platforms reflecting communications from the relevant time period to, from, between, and among the subpoena recipient relating to or discussing any formal or informal investigation or prosecution of Hunter Biden, including but not limited to any decision, referral, or request to investigate or not investigate or charge or not charge Hunter Biden. So again, because of this kind of subpoena, which of course I'm going to say incorrectly, all right? So I'm trying to just write it. All right, so this is the subpoena they're asking for, and it's basically a production request. So bring the documents with you is what they're saying. So number 2, next, all documents and records, personal or official platforms reflecting communications from the relevant time period to, from, between, or among the subpoena recipient and any executive branch official, political appointee, Department of Justice official, government agency, government official, or staff person, cabinet member, or attorney for the President, Trump, personal or other, discussing or concerning Hunter Biden. Duce tecum, Duce tecum. Okay. Tecum. I know. Oh my gosh, the Latin. It's too much. Number 3, all personal records, including diaries, journals, memoirs, memorandum, or notes from the relevant time period discussing or concerning Hunter Biden, including but not limited to reference to any formal or informal decision, discussion, or request to investigate or prosecute Hunter Biden. Whoa, that's, yikes, that's pretty specific. And yet not at the same time. Yay, Latin! And number 4, any documents and records produced by the subpoena recipient to the House Select Committee to investigate the January 6th attack on the United States Capitol that reference or discuss Hunter Biden. Hunter Biden filed this. He filed this motion for subpoenas. Who wrote about him in his diaries? Excellent question. They want to figure that out. As discussed below, this information would be both relevant to and admissible in pretrial motions and evidentiary hearings. To date, the defense has not received such material in discovery from the prosecution or elsewhere, notwithstanding specific discovery requests, and some of this information likely resides with the DOJ. Nevertheless, this information is essential to Mr. Biden's proper preparation for his defense. Now, we'll bump down here. We've got, should the subpoena recipients have any concerns about the sensitivity of producing these records, the parties can surely come to an agreement on the terms of an adequate protective order concerning them. So adding that in, before the government intones its stock phase. Hold on, back to the beginning. Before the government intones its stock phrase, this is no fishing expedition. The statements described in this motion actually occurred, and the events that transpired both before and after June 20th of 2023 are well known to the court. Mr. Biden seeks specific information from 3 former DOJ officials and the former president that goes to the heart of his defense that this is possibly a vindictive and selective prosecution arising from an unrelenting pressure campaign beginning in the last administration, in violation of Mr. Biden's Fifth Amendment rights under the Constitution. Moreover, each of the former DOJ officials has known contacts with then President Trump concerning Mr. Biden, and according to recently released IRS investigative case files, each had a hand in one way or another in the still ongoing investigation of Mr. Biden, either in Delaware or elsewhere. Lastly, as reflected by both the handwritten notes taken contemporaneously by Mr. Donahue involving Mr. Rosen and Mr. Trump and Mr. Barr's vignette in his recent book, boy, everybody in their books are really giving us a lot of additional evidence, aren't they? I think that's very interesting. These individuals are, in fact, likely to have relevant materials in their possession that are responsive to Mr. Biden's document requests. Here's the argument then that is set out. So we'll get into some of these legal issues here. I'll take a quick tea break. But he's going to go into why he's got grounds in order to make this request. All right, here we go. Number 1. Legal standard for issuance of Rule 17 subpoenas. So again, Rule 17 is set out in the Federal Rules of Criminal Procedure. Rule 17 specifically covers subpoenas, and 17C goes into producing documents and objects. So that's specifically what they're talking about here. So, subsection C provides in relevant part, a subpoena may order the witness to produce any books, papers, documents, data, or other objects the subpoena designates. The court may direct the witness to produce the designated items in court before trial or before they are to be offered into evidence. When the item arrives, the court may permit the parties and their attorneys to inspect all or part of them. So that's the direct language from the rule. Rule 17C implements the Sixth Amendment guarantee that an accused have compulsory process to secure evidence in his favor. And we've got lots of case law supporting that. So I'm not going to get into the details too much of that. Again, it's just explaining why we have that subpoena power, which is guaranteed by the Sixth Amendment. So let's bump down to the next paragraph. In United States v. Nixon, which is a great case setting out precedent and subpoenas, the Supreme Court set forth the standards for issuing a Rule 17C subpoena. Adopting the test devised by Judge Weinfeld in United States v. Iazoa, pretrial production of evidence is appropriate where the requesting party can demonstrate. So this is the test, everybody. They have to meet the burden of the test. We've got a 4-part test here. 1, that the documents are evidentiary and relevant. So he has to show that the documents, like the diaries and such he's requesting, are evidentiary and relevant. 2, that they are not otherwise procurable reasonably in advance of trial by exercise of due diligence. 3, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And 4, that the application is made in good faith and is not intended as a general fishing expedition, which is the key. And then the Nixon case added extra, can be boiled down into 3 primary factors. So further distilled this test into 3 factors. Number 1, thank you, relevancy. Number 2, admissibility. And 3, specificity. I think they may have a specificity issue, in my opinion. I'm not sure they are specific enough, but we will see. Said another way, Rule 17C is designed to help obtain relevant evidentiary material that the moving party may use at trial. While the bulk of the case involving Rule 17C concerns production prior to trial, the court authority under Rule 17C relates to a judicial proceeding, which includes pretrial evidentiary hearings. In this case, production of documents by each of the subpoena recipients prior to trial may be used either in a pretrial pleading or in a pretrial evidentiary hearing on Mr. Biden's motions to dismiss the indictment, or potentially another issue. Accordingly, Mr. Biden seeks pretrial access to the documents sought in order to allow him sufficient time to review them and prepare his defense consistent with Rule 17C, which permits courts to require production of pretrial or before they, pretrial or before they are offered in evidence. Number 2, so here's our second argument. The information sought from each of the subpoena recipients is relevant. So let's see. The information Mr. Biden seeks from the subpoena recipients is relevant and material to a fundamental aspect of the issues in his defense that will be addressed in pretrial motions and possibly as impeachment of trial witnesses. Impeachment means cross-examination or reducing the credibility of a witness. Should the case get that far, whether this investigation or prosecution arose because of or in response to any executive branch official or other outside influences placing undue pressure on government officials to investigate, formally or informally, or prosecute Mr. Biden. Subpoena recipient President Trump knows full well that improper pressure on prosecutors to bring criminal charges against an individual for political reasons is grounds for seeking to dismiss an indictment because President Trump recently filed a motion. Now we're getting into the tea, everybody. Filed a motion to dismiss on this very basis in one of his criminal cases. This would be the DC case. Similarly, let's bump down. Actually, we have a footnote here. Here we go. Demonstrating hypocrisy and a lack of principles, just last week, Mr. Trump insisted that the weaponization of the judicial process is wrong, and it is, but Mr. Trump claims that he would be justified in weaponizing the judicial process against his political enemies because he believes that he's been a victim of such weaponization. This claim certainly undercuts any notion that Mr. Trump is above such misconduct. Ooh, ouch. Ouch. That's a harsh burn. I'm loving this for him. Oh my goodness. All right. Similarly, subpoena recipient Attorney General Barr has explained precisely why the concern Mr. Biden raises here is problematic for this indictment. Again, we're quoting Barr. The essence of the rule of law is that whatever rule you apply in one case must be the same rule you apply in similar cases. Treating each person equally before the law includes how the department enforces the law. We should not prosecute someone for wire fraud in Manhattan using a legal theory we would not equally pursue in Madison or Montgomery, or allow prosecutors in one division to bring charges using a theory that a group of prosecutors in the division down the hall would not deploy against someone who engaged in indistinguishable conduct. And then we have footnote 17 here. Remarks by Attorney General William Barr at Hillsdale College Constitution Day event. Interesting. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And that's Federal Rule of Evidence 401. A document is material to the defense if there is a strong indication that it will play an important role in uncovering admissible evidence, aiding witness preparation, corroborating testimony, and assisting impeachment, so discrediting the witness or rebuttal. And then we're just citing a lot of case law here. So let's bump to page 12. Requests 1 through 4, again, we had gone through each of those on the previous page, only seek communications or personal records reflecting one issue to determine whether the subpoena recipients or those with whom they worked, pressured, discussed, influenced, or requested any investigation or prosecution of Mr. Biden, including whether an executive branch official placed any undue pressure on another government official to undertake the same. From a Fifth Amendment perspective, it is essential for Mr. Biden to know whether anyone improperly discussed, encouraged, endorsed, or requested an investigation or prosecution of him, and to whom and under what circumstances. The information sought would demonstrate that fact. This is especially true in light of the fact that no new evidence related to these charges emerged between June 20th, when the plea deal was first presented to the court, and July 26th, when the prosecution reneged on its deal. And in fact, only more favorable case law on this issue has developed since then. And we have footnote 18 here. In a closed-door deposition with congressional lawmakers, Mr. Weiss denied bowing to political pressure and said that the decisions had been based only on the facts and the law. Again, though, no new facts have emerged after Mr. Weiss had supported a plea deal and the diversion agreement, and the only pertinent legal development had been the Fifth Circuit had found the prosecution's principal gun charge unconstitutional. The only intervening event between then and Mr. Weiss's decision to bring more serious charges was the Republican political backlash against his prior efforts to resolve this matter based on the facts and the law. So that's a lot. Thus, the prosecution's change of heart appears to be in response to political pressure rather than anything newly discovered in the investigation of Mr. Biden. Because such evidence, only some of which has been disclosed already, would tend to undermine the prosecution's allegation that this case was free from any political interference and was not of a selective or vindictive nature. Mr. Biden's requests are relevant and material under the requirements of Rule 17C. So, all right. And then into 13. Now we are almost at the end here. We only have 2 pages left. So we're going to, again, get into more of the justification for the request of these subpoenas here. Number 3, the information sought from each of the subpoena recipients is admissible. So that's the second part of the test. Excuse me. All of the information sought from the subpoena recipients would be admissible in a pretrial motions or in an evidentiary hearing, or, depending on the author and recipient, to impeach a trial witness. Generally, relevant evidence is admissible for all purposes except as provided otherwise by the Constitution or an act of Congress. So, and then this is explaining again more about the subpoena. To satisfy the admissibility threshold, Mr. Biden must merely make a preliminary showing of the potential evidentiary uses of the material. Citing the Nixon case again, holding that there's sufficient preliminary showing the material sought as part of Rule 17c subpoena is admissible where a requesting party has demonstrated valid potential evidentiary uses for the material. The communications and personal records, yep, I'm just keeping an eye here on the comments too, sought satisfy the threshold standard for the admissibility under Rule 17c. The statements or contemporaneous notes, diaries, or the like would be relevant and offered for one, the fact of the communications themselves, demonstrating that such pressure was communicated, and two, bias or improper motive on the part of the prosecution or its witnesses. It would be material to Mr. Biden's defense if pressure had been placed on prosecutors to investigate or charge Mr. Biden for political reasons based on who he is and not on the conduct for which there's probable cause to believe he engaged in. So that's a pretty bold statement. And then number 4, the information sought from each of the subpoena recipients is specific. Now this, in my opinion, with how they phrased it here, is probably the weakest link. Again, just in my opinion, but let's see what their explanation is. Mr. Biden has identified the information he seeks from the subpoena recipients with sufficient specificity to satisfy Rule 17c. The requests are sufficiently narrowly focused on a group of records likely to contain helpful documents about the communications or personal records possessed by the subpoena recipients concerning a possible investigation or prosecution of Mr. Biden, and thus cannot be said to be a fishing expedition. In this context, specificity embodies both the good faith and the fishing expedition concepts that the Nixon court imported from IOZIA. Interesting. Moreover, the requests are limited in the following ways. Let's take a look at that. Number 1, topic. Requests 1 through 4 only seek communications or personal records reflecting one issue, to see whether the subpoena recipients discussed, participated in, or requested any investigation or prosecution of Mr. Biden, including whether anyone else placed any undue pressure on other government officials to undertake the same. Custodian. Records 1 through 4 only seek records from a handful of relevant former DOJ individuals who would be the only ones to possess copies of such documents, communications, or personal records, as reflected from the communications already made public. Time period. Requests 1 through 4 are limited to the relevant time period for which former President Trump was in office and thereafter, January 20th of 2017 to the present. I'm not sure. I mean, it's definitely helpful. I think it helps the specificity, but I'm not sure if it's enough yet, in my humble opinion. As explained in the introduction, Mr. Biden seeks specific information from 3 former DOJ officials and the former president that goes to the heart of his pretrial and trial defense, that this is possibly a vindictive or selective prosecution that arose out of an incessant pressure campaign that began in the last administration in violation of Mr. Biden's constitutional rights. Moreover, each of the former DOJ officials from whom Mr. Biden now seeks documents had known contacts with then-President Trump concerning Mr. Biden, and according to now public IRS investigative case files, each of these officials interacted in one capacity or another with the teams investigating Mr. Biden, either in Delaware or elsewhere, as reflected by the handwritten notes taken by Mr. Donahue involving Mr. Rosen and Mr. Trump, inquiring about investigating Mr. Biden for real, as well as Mr. Barr's vignette in his recent book about Mr. Trump's inquiry about Mr. Biden. These individuals are likely to have relevant and responsive materials in their possession that are at the center of Mr. Biden's documents requests. As described in this motion, Mr. Biden seeks these materials in good faith and maintains that they are highly relevant and material to his pretrial and trial defense. Accordingly, Mr. Biden submits that these requests are narrowly tailored to satisfy the requirements of Rule 17c. In conclusion, for the foregoing reasons, Mr. Biden respectfully requests that this court enter an order pursuant to Rule 17c directing that a subpoena, in Latin, be issued to each of the subpoena recipients for the documents and materials described in requests 1 through 4. Super pages 7 and 8. Mr. Biden further requests that each of the subpoena recipients be required to provide any responsive documents and materials by December 1st to allow Mr. Biden sufficient time to review the material in advance of any necessary evidentiary hearing and or trial. These requests do not prejudice or constitute a waiver of Mr. Biden's pending discovery requests under Rule 16 and Brady and his progeny. Of course, the Brady rule is the rule where prosecutors have to give any exculpatory evidence to the defendant. So there we have it. What are our thoughts, everybody? Do you think his request is narrowly tailored? He's asking for any documents, any kind of records of discussions of bringing the prosecution against Hunter. I'm wondering. I'm not sure. I'm really not sure if it's narrowly tailored enough to satisfy. Too broad. It seems broad to me, but these kinds of subpoenas are, broad in nature. It's pretty broad. Yeah, I agree. Again, they're asking for any kind of documents that would have shown any kind of planning or intent. Let's take a look here again. I mean, they're supporting why they think that each of these people would have that kind of information. And this is part of their defense, but I think we can go here. These are his 4 requests. So all documents and records reflecting communications. I mean, again, they're trying to be specific about a formal or informal investigation, but it seems pretty broad. The language seems pretty broad to me. I think they will be able to meet the request. Perhaps. Seems fair, but it could be a little bit more specific. Okay. Was this document very wordy? No, this is pretty typical. This is a pretty typical filing here. I would say this one's pretty much to the point, and I've seen a lot recently that are not. But this one's pretty good, I think, in my opinion. They did a pretty good job. But I think that their requests, though, are a little too broad. Public info on Trump's pressure is what necessitated this. That's a good point. I think that's a really good point. The fact that he went on and said, hey, if I'm reelected, I will use the department for my own purposes, which shows, he could do this. He's already said that this is something he would be willing to do. So maybe he already did it. And, I think that's an interesting argument. I'm not sure about that. Did he ask for emails, text specifically, or is it the under the communication request? So we have any records, any documents that could include text, could include all of that information. Diaries, journals, memoirs, memorandum, any kind of records reflecting communication. What is Messer in law terminology? Let's see. Let me see. Let's find where it was here. Directing. So it says here, Mr. Biden now moves his court to issue 4 subpoenas directing Messrs. Trump, Barr, Donahue, and Rosen. So instead of saying Mr. Trump, Mr. Barr, Mr. Donahue, this is the plural. So it's just the title given to 4 people in a row or multiple misters. Yeah, thanks, Jessa. Yep, good job. That's the best thing ever. I know, right? As a group of men. Could be. Yeah, no, I think that's great. I mean, we don't use that kind of terminology very much. I didn't know that either. No, I had assumed it was some kind of a title, but is there a typo or not? I don't think so. I think that's exactly how it's it's spelled. I think it is MSSRS. That is how it's legally spelled, I believe. They use that term in Harry Potter. Oh my gosh. Oh, we love that. We love that. Yes, you got it, Estelle. That's right. Multiple men in my house. Right, right. Exactly. Very interesting. Multiple men. Yep, we got it. We got it. Yes. Yeah, I'm glad you brought that up. I had assumed that it was against a title, but that's how it's spelled. We learn something new all the time, don't we? So which document is this? So this is Hunter Biden's motion for subpoenas. So production of evidence. So subpoenas, duces, tecum, tecum, I don't know. My Latin's awful. But this just means a production of documents. So he's saying that he wants these four fellas to bring information, to get information to him regarding whether or not they discussed prosecuting him in the past. That's really what this case is about. Yep. Are you sure an attorney? Well, according to my student loan payments I'm due every month. Oop, they're gone. Oh, that's funny. Oh my gosh. Yes. Multiple misters. Yep. I think that's really interesting. Yeah, I mean, I've got a few years left on those. So, so I think it's really interesting. This is kind of the first time we've seen this lob back over the net, because we've seen Trump and a lot of those people saying, hey, you guys are doing this as a way to weaponize the system, or you're coming after me because it's politically motivated. Now we've got, Hunter Biden coming in and saying, hey, my prosecution was politically motivated. Now, was it not? I don't know. But he, at least someone here, he has filed it, and he's putting that out there now, that one of the defense strategy he's going to attempt to use is that this was politically motivated and biased. I do try to I paid for the title. Yes, and I will pay for that title for a long, long time. Oh my goodness. Yeah, and it's a lot of mumbo jumbo. I think that's accurate. I think that's very accurate. Okay, did Trump miss his reply motions today in the DC case? I don't see anything on the docket. I haven't either. So I will take a look. This was, again, kind of a little bonus live here, everybody, to just kind of go through this. I will be back again at 7. And I do plan to do an update on the Trump cases at 7. I had originally planned to go on YouTube, or my Tube of You channel tonight, but unfortunately my computer setup here is not going to allow for it. Oh my gosh. So in about an hour, it'll be in about an hour. So I'll probably are going to use against, yes, I mean, there's a lot. Today was a busy day again. It certainly was. There was quite a bit going on. So I will go ahead, everybody, and kind of hop off here for an hour, and I will be back again here on TikTok. I do have the new code of conduct that's been set out, the ethics rules for the U.S. Supreme Court. It's short, so I will go through that, but I'll also update everybody on the cases. So I did want to come in, though, and talk about this. I thought it was a very interesting motion, an interesting request. So I will be back again in an hour, everyone. Thank you for coming and hanging out with me. And as always, thank you to my amazing moderators. I will be back again in an hour. So we will see you all in just a little bit. Catch y'all later.